Everyone, welcome to the One Take Show. My name is Kaustubh Srivastava, and today we are in conversation with a very special guest. Our guest today is Mr. Mohit Khubchandani. Sir is an international dispute resolutions attorney. He is also research fellow with the United Nations International Law Commission. And today, Sir has taken time off his very busy schedule to talk about his experiences in law school, what inspired him to explore all these opportunities in international law, what we can learn from it. He is also going to talk about two very interesting topics. Firstly, the impact of COVID 19 on international arbitration, and secondly, the World Trade Organization appellate body crisis. If you like this episode, please make sure that you like, share, and subscribe. If you have any feedback, suggestion, please feel free to reach out to me. I would love that. At the end, we are recording this episode over Zoom, and hence the voice quality might suffer a little bit, but trust me, the conversation, it really compensates for every bit of it. And hence, ladies and gentlemen, without further ado, let's jump right into the discussion. Hello, sir. Welcome to the One Take Show. I am so excited to have you on my podcast for multiple reasons because I've been following your work for such a long period of time and I've been inspired by everything that you've done. You've been a rock star, a superstar for every law student who's ever aspired to somehow indulge into international law and have tried to make their way into the field. So thank you so much, sir, for taking time off your very busy schedule and gracing this podcast.
Dear Kaustubh, I think you've given me a lot of adulation. Perhaps I don't deserve that, but thank you very much for having me on your podcast. And kudos to you for coming up with this brainchild and setting up this podcast, which gives rookies like me the opportunity to come and share our very little experience that we may have had. And to all those who are listening, I hope that you're keeping healthy and uplifted during these times. Thank you.
Right, sir. So I believe you're being really humble though, but I have to, or to all my listeners who would love to know about everything that you're associated with right now and everything that you've been engaged with in the past, but I won't be able to do justice to it because I want to hear it from you and I want my listeners to hear it from you. So if you could tell me a little bit about that.
Okay, so it's actually tough to sum it up, but basically I've endeavored to be an international disputes resolution attorney, and it's now actually exactly been 5 years since I graduated from law school and since I have been treading on this path. And all that I can say is that I have been passionate about public international law and international arbitration with a lens of environmental law. And I have tried to explore these areas through several lenses in the sense that I have tried to be a litigator. I used to work at the Office of the Attorney General for India prior to going for my master's at Stanford Law. So saw it from a practitioner's point of view, and thereafter I was a teaching assistant after my graduation at Stanford Law in a course on international investment law. So saw it as an academic briefly. Post that, I have been serving in several positions at United Nations agencies as primarily a policy maker, and currently I'm working as a research fellow at the United Nations International Law Commission, and I'm keeping all my fingers and in fact my toes crossed because I am yet to go to the International Court of Justice towards the end of this year as a judicial fellow, but that of course is contingent upon how conducive our travel restrictions are. So this is a bit about myself and what I've been doing since the past 5 years.
Right, sir. So I believe obviously the fate favors the brave, and this is one of the most inspiring aspects that I have come across and want to come across because we all want to learn from your experiences. Very particularly with respect to your experience in law school. How was your experience in law school? Like, were there your specific experiences, something that stood out, something you want to talk about?
Okay, so thank you very much for asking this question because usually I'm asked about my LLM experience at Stanford Law, but I believe that this does not apply just to me, but to every law student. And the real foundation that we build for ourselves is during our law school years, which is also a longer journey. And perhaps these days, most of us do the 5-year law path. So I did my graduation at Amity Law School, Guru Gobind Singh Indraprastha University. And at the time when I joined law school, I would say that it used to consistently feature in the top 10 to 15 law schools in the country, but definitely not in, let's say, the top 5. I mean, that's a settled debate, so I won't even get there. But the point that I'm trying to convey here is not the ranking of the law school, but the fact that when I got into law school, I knew this fact and I knew this reality. And I also knew that it would require a mammoth overhaul for me to place myself at par, or even for that matter, transcend some of the applications at foreign universities for LLM programs, and that had always been a dream. So I was in fact more motivated than disheartened at that fact. And I mean, courtesy to some spiritual faiths that I follow, and courtesy to a never say never philosophy in life, it was perhaps that fact and that drive which made me completely immerse myself in any and every opportunity that came my way. And in fact, when there was no opportunity, I created opportunities for myself. And I think that's something that I can elaborate later. But there are primarily, I think, 3 things which stood out for me, and 3 very distinctive opportunities that I got in disguise as a result of being at my law school. So the first one, specifically in the context of co-curricular activities, was that my law school needed a lot of structuring at the time I was there. And all the societies were primarily student driven. So that actually inculcated a habit of doing each and everything on our own without being spoon-fed or being directed about anything. It's like throwing someone in an ocean who doesn't know how to swim, but eventually does learn how to swim. So that was very helpful, and it's still a lesson that helps me immensely in any and every pursuit of my life. Secondly, I would definitely point this out, that due to the geographical advantage, that is my law school being in Delhi NCR, which is the hub of law practice in India, I was in close vicinity with a lot of legal minds. And so applying for internships, etc., was perhaps easier. And I must confess that. And finally, but most importantly, I think my law school journey was a journey of many firsts, in the sense that it was a rewarding experience and an opportunity, in fact, to institutionalize the law school's first ever International Law Society. And from that to what I'm told by my dean, I had the absolute honor to be the first person from my law school to secure an admission at Stanford Law. So that was my journey at law school by and large.
Right, sir. I mean, one of the most important facts here was that you made opportunities amidst all the challenges that you had and the opportunities that you had. Perfect mix obviously works the best. But when we talk about law school, there is always this very exclusive concept of mooting, debating, research papers, all these curricular activities which usually contribute to, let's say, someone's LLM application, their personality, their career prospects, and stuff like that. Were there any such activities that have influenced you, or any such activities that you were engaged with?
Absolutely, Kaustubh. And I think you already know about what comprises of the best ingredients in an LLM application. and I didn't do anything dissimilar to that. I think I still am, and I was, a jack of all and a master of none when I was at law school, and I unabashedly must confess that. I took part in debates in MUNs, particularly moot courts and international law moot courts. And not just that, on the extracurricular front, I was very active in theater, in dancing, and I also wrote and published a little. And these things essentially comprise of great applications, and that was always a dream for me. So that's what I did.
Right, sir. So you mentioned that you believe that you were the jack of all trades. Is it really a bad thing? Because in my perception, that's actually a good thing. In a law school, I personally try to be a jack of all trade, and I tend to participate in all the competitions, especially when I get to see achievers like you as an inspiration. I get to participate in so many other competitions as well. Is really that a bad thing?
So I think we must understand this from two prongs. If we pick one or a few areas of law and we are taking part in different activities in and within those areas of law, then we are not really being a jack of all and a master of none. In fact, we are exploring one subject matter in the best possible horizon that exists for that subject matter. So perhaps I should rephrase myself in the sense that I was not so outlandish that one day I was doing banking law and the other day I was doing competition law and the third day I was doing international law. No, I was not doing that. And that is detrimental for applications. However, picking a few areas of law, in my case, if I speak about domestic law, then it used to be environmental law, and as a byproduct, obviously constitutional law. And as far as international law was concerned, I was always interested in human rights law, law of the treaties, environmental law, and humanitarian law, a little bit of trade law and investment law. But if I were to say that I also sort of explored something like anti-competitive trade policies, I will have to confess, no. I mean, I'm still getting there, but coming back to the point that being a jack of all can be done in some activities, not in subject matters.
Right, sir, because this is a very important point, especially for me, because when you tend to participate in a lot of things, you tend to lose track of what you are trying to somehow create your niche in. And this is something that I will take away from this segment of the conversation. But this has actually inspired me to ask you this question. What gave you the idea, or what inspired you to navigate your way into international law? Like, you were inclined towards international law ever since you were in law school, and what exactly inspired you to do the same?
Right. So I have actually said this before in an interview that happened just day before yesterday, but perhaps I'll reiterate this in a different tangent here. So my interest to pursue law began with an interest in international law. So the reason I wanted to go to law school was because I wanted to practice international law and not the other way around. So this was because I generally, as a person, have an avid interest in any and everything that exists around me. I think I have this very inquisitive brain and I question a lot, and sometimes to the extent that it bothers people that I'm asking so many questions. But I think the beauty of international law is that inevitably you are required to know so much about general knowledge and the things that exist around us in order to be a great international lawyer. So much so that the depth of knowledge should also extend to outer space, relating to international space law, which also happens to be one of my very, very cherished areas of law. So that, coupled with the fact that it might sound like a cliche to you and some others, but I genuinely do believe in international justice. So international law for me was the tool to put my efforts in the widest possible use and impact that I can make with my work. And often there are very gray areas in international law which gives you a lot of scope for creativity, even in policy making, in arguments. And you can create a niche for yourself in a topic that you might create, and a topic that you might raise up a few years down the line. And all my wishes to everyone, maybe someone amongst us has a doctrine in their name. That is only possible in international law because it's still in its nascent stages, as I believe. So this was really my driving force, if I may put it that way.
Right, sir. So this is very interesting because you went on to. I'll pick the first one first. You went on to work with the permanent mission of India to United Nations in New York, which is a dream. Like, it's hands down a dream. How did you like? How did you get this or make yourself somehow navigate your way to this opportunity? And what was your experience with this opportunity?
Right. So I think this opportunity by far has been the most exhilarating opportunity that I've had in my legal career. And with due respect to the learnings that I've had in all my other opportunities, I think this perhaps placed me in the closest proximity to international lawmaking and the real action that exists within this realm, which is very rare to see.
This wow, this is a really inspiring story, though. And then you went on to work with multiple projects with United Nations as well. We have two major projects that you worked for. I would generally leave this for you to talk about, for my listeners to really understand and cherish the kind of experience that you've had. But how did you make your way? Like, how did you navigate your way to the United Nations, and what all project did you work with?
All right. So when you work at a permanent mission to a country, then you are exposed to a very wide array of subject matters within the realm of international law, which you may or may not be able to practice at certain UN agencies, which are set up for specific purposes and specific areas. So of course, since I had applied to a lot of positions prior to getting into the mission, then I actually knew that what is really the fodder that they require. And those were exactly the tasks that I undertook at the mission. And in fact, if I come back to the point of creating opportunities, I used to note down certain resolutions or conventions which were being negotiated at the United Nations General Assembly and Security Council. And I used to go to the concerned people at the mission and say that this is what I would really like to work on. And that then obviously constituted a part of my application. And then when I made UN applications after having had this experience, then I finally got an unpaid internship. And mind you, this position at the permanent mission was also unpaid. So it was really a tough call at the time that I had to take for myself. And I'm very grateful to my parents for their support during this time. But perhaps they also saw the longer goal that I tried to achieve through that. So in a sense, what I'd say is that the next time when I made these applications, I had many things to speak about. And despite having had nearly 3 years of working experience in India, despite having had a master's after that, I still had to work in an unpaid position. And then I finally got promoted as a consultant at the UN. But that's not the end of the story, because then comes COVID-19 in the picture. And then my consultancy had to end for several reasons. And right now, as a research fellow at the United Nations International Law Commission. Even though it's a very enriching experience, it is still not paid. But my ICJ position, which I think is courtesy to the experience that I've had at the ILC, which is very similar to what we practice in terms of subject areas at the ICJ, has led me to that position, which will be handsomely paid. So I'm looking forward to that now.
I'm sure, sir, because the story itself is so inspiring in so many ways. Not just the fact that you've had this journey and you made it, you had all these opportunities, but also the fact that you sacrificed, you've accepted that, and you've still worked. And this is the principle that not a lot of, let's say, the experiences or interviews and stuff like that teach the law students. And law students really need to know this, because I say this from a very selfish point of view. I have not been exposed to this reality yet, but from a very again, from a selfish point of view, for a law student, what would your suggestions be? Like, what would your opinion be as to how law students can navigate their way while also being in law school or after law school, in order to make a career in international law, or to somehow navigate their way to the opportunities in international law?
Right. So I will address your question in two parts. The first one about the listeners who might be in law school right now. When you're a law student, I think you can do a lot of things which you cannot do once you graduate. So when I was in law school, I at the time didn't have any expectations about what I might get later on after graduating. I did not know that I will land up at the United Nations, and I must say that I still don't know if I will be at the United Nations for long. But in a sense, whatever you are doing should be for the purposes of striving for excellence in that one field, and you will be amazed to see where that entire hustle takes you. So be a hustler. And again, I think the theme of today's conversation always revolves around creating opportunities for yourself. So participate in a lot of moot court competitions, particularly if international law is what we are speaking about, because a lot of moot court competitions deal with the International Court of Justice as a simulation. And I had the great fortune of taking part in the Philip C. Jessup, Stetson, Manfred Lachs, and the Willem C. Wiz Vienna moot court competitions. And I think that was really something that paved my way and bolstered my understanding of international law before even making my applications. I knew how to make those applications because I had by that time developed some form of understanding. And then more importantly, these moot court competitions give you a level playing field, which is very important. So when I was addressing about my law school not perhaps being the best law school in India, taking part in these moot court competitions dissipated any of those differences. On a given day, you could be the master of the game. So it all squarely depends on how much work that you've done, and then you can see the best practices around you, and whether you win or you lose. I mean, I had a lot of disappointments during my mooting days as well, and then some success. But each of those opportunities, and as a tangible benefit, I can tell you this: the best publications that I've had till now are the researches of my moot court competitions. So essentially, I derived a dual benefit out of each and every of my moot court competitions. So it was never really a win or a loss. It was always a win-win. So I think that is one aspect which doesn't need any favor, any opportunity from anybody. Just work hard. I'm sure that law students have an internal selections mechanism in place. Get selected for moot court competitions. Whether you get the best one or not is not really a consideration, but be your best in the moot court competition that you're getting. Now, trying not to focus too much on moot court competitions because I think I'm biased towards those. But besides that, I think you can just pick up a book on international law, start reading about it, whether or not it comes on your resume, but it helps you somewhere down the line. Use a lot of LinkedIn. I have been saying this time and again on all social media platforms to people. Look at people's profiles and what they particularly did in their early days. And for now, who are young professionals, I would say that specifically in the COVID-19 time, make use of the wonderful opportunities that webinars give to us. I still believe that there's so much that I don't know, and I register myself for any and every webinar that I see online. Whether or not I can attend it is different, but I register myself, and I'm learning so much every day these days from the best of the best, not just in India but in the world, because it is only in these times that we are having such opportunities for free. Otherwise, in the past, there used to be conferences for the very same purposes, and we would have had to travel for so many miles just to hear the same things that we can just now hear on the click of a button. So this is something that young professionals can do.
Right, so I will come off clean. I have done the LinkedIn part. I have followed your profile on multiple instances. I have made notes and I'm going to copy them step by step. So if in case there are surprises in the future, they're not really surprises, they're pre-planned. Having said that, this COVID-19, although with all the negativity that it comes with, the positive part for me personally has been that I have this opportunity, the one take show where I can interact with let's say leaders in the field and professionals like you and learn from your experiences and grow with it. And this also gives me the opportunity to actually talk about substantial issues of law which is being affected by this once in a millennia sort of a situation, this COVID-19, the kind of not the effect that pandemic is happening. And this brings me to the first very substantial question that we are going to discuss in this conversation, that is, how exactly is COVID-19 affecting or impacting the international disputes resolution? Like, what is your opinion on this entire change that pandemic is creating across the world?
Right. So, of course, ever since the COVID-19 outbreak, all industries have been affected. And as a result of industries being affected, there is litigation all over, whether it's domestic or international. So it has a square impact on international disputes resolution, and in the sense particularly on international arbitration, which is immensely affected as the current situation can be construed as one of force majeure. Now, when we speak of international arbitration, essentially we're talking about international commercial arbitration between private parties. Secondly, we speak about international investment arbitration between typically an investor in a country, and the third one being state-to-state arbitrations between nations. Now, I think this question actually gives me the perfect pedestal to address one very important facet in my journey, in fact, which I perhaps did not address earlier. I feel that it is extremely important to have an in-depth understanding of public international law in order to excel in international arbitration. And my response to this question will perhaps be self-explanatory. So coming back to the question, now, while entities might claim general defenses such as preclusion from expropriation, such as fair and equitable treatment standards under several multilateral or bilateral investment treaties, the real defense during something as unprecedented as COVID-19 can be claimed under customary international law. Particularly if we revisit the United Nations International Law Commission's draft articles on state responsibility, And I'm not saying so because I currently work there, but this is really the answer. If we look at the term circumstances precluding wrongfulness in these draft articles, what we see are a few defenses which exist within Articles 23 to 27 of this document. If we speak about Article 23, which is force majeure, a successful claim under that can be fulfilled if 5 conditions, and all 5 of them, so essentially it's a conjunctive test, are met. The first one is if there is an unforeseen event, which COVID-19 is. The second one is that the event must be beyond the control of the given state. This is perhaps an arguable point and perhaps a premature point to discuss, because I will say there's a certain country X which is being investigated right now by several countries. If we say that it was materially impossible to perform an obligation under a particular treaty, that will also be tested on the basis of evidence. That the state has not contributed to the situation is something that is squarely related to what evidence tells us in the days or weeks or months to come. And finally and fifthly, that a state must not have assumed the risk of the situation occurring. So the point being that this defense can be claimed by a certain country X or several other countries if disputes are raised by investors or other states on those countries if all these conditions are met. In a sense, that they can be precluded from their treaty obligations, which is actually another concept in the Vienna Convention on Law of Treaties, Article 62, which speaks about rebus sic stantibus, which is the impossibility to perform a treaty obligation. The next condition is distress, which is enshrined under Article 24 of the draft articles. And finally, there is Article 25, which is necessity, that a certain measure was required. So therefore, coming back to my initial observation that these two areas of law run in tandem, in a symphony, if I may put it that way. And essentially, the answer would lie in such defenses. And I'm very sure that there will be a lot of such litigation and a lot of such defenses will be claimed by countries. And an example that comes to mind, particularly in the case of the necessity defense, was in the aftermath of the Argentine financial crisis. So this would be my take on the entire situation revolving around international arbitration.
Right, sir. That is a very in-depth answer as to how COVID-19 is affecting the international dispute resolutions. We understood what are the various conditions that attach themselves to the concept. In a sense, there is another very interesting development in the area of international law, which I would love to discuss. It's regarding the World Trade Organization appellate body and the crisis that is emerging with the tussle that the United States and the World Trade Organization is happening, and the kind of situation that it is creating for not just the World Trade Organization but for all the countries. I would love to know, like, how much of an impact will the World Trade Appellate Body crisis will have on this entire pandemic that is currently affecting the world. Like, in a way, any pandemic-related claims, if they raise before the World Trade Organization for the appellate body, there is no such official appellate body in place, the best of my knowledge, if I'm correct. And if that situation arises, what exactly will be the impact?
Right. So thank you for this question, because with the help of this question, we would have covered the realm of public international law, international investment law, and international trade law. And I think you're making me push all my limits upon my understanding of international law by and large.
So one
So,
opportunity, I am not letting this one go. I'm going to ask every question there is.
so forbid my inaccuracy if there is any during answering this question. But the WTO appellate body crisis, let alone the COVID-19 crisis, was very big in itself. It was a huge impediment upon all of us. To put it in simpler words, the WTO disputes redressal mechanism. Now, of course, people have been saying that, and scholars have been saying that this is because of several adverse decisions that they've received. But their excuse, or rather justification, to lose this trust is because they feel that the WTO disputes redressal mechanism, and specifically the appellate body, has on several occasions transgressed its power and has acted in what we call judicial activism, which is a two-edged sword and is criticized even in domestic regimes. So, as a result of this, what has happened is that they have stopped nominating members to the appellate body. And currently, there is only one member in the appellate body, whereas there are 3 required to adjudicate any dispute. So, in other words, it's defunct at this moment as we speak. Other countries have been making several pleas and have been resorting to several diplomatic means to resolve this dispute. But at the end of the day, the major powers do have a leeway, especially with their allies, and are able to, if I may say, arm twist and get their deals on the table. So, as I mentioned, that this was already a huge crisis. Now let's infuse a bigger crisis, which is COVID-19, in this already mammoth-like crisis. Now, particularly issues pertaining to the agreement on trade-related aspects of intellectual property rights, what we call as the TRIPS agreement, relates to issues such as flexibility of obligations on countries to give fair share of prices to the future patentability of vaccines. And this is something that is yet to come at any and every given point of time in the years to come. So there are particularly 2 articles in this agreement. Article 8 speaks about adoption of measures by members which are necessary to protect public health and nutrition. In a sense that this article gives an exception that if any measure that concerns this realm, then in accordance with the conjoint reading of Article 31, which authorizes the use of a right holder's asset, and in this case, patents by countries, in a manner which does not monopolize, or in some occasions actually renders very less profits to the developer in a crisis situation like this. Now, if we speak about not just the prospective vaccines, but hydrochloroquine, and India has been in the news about this, and it has been supplying this to a lot of countries. Now, it only makes me wonder that if hydrochloroquine was of a price which was very high, then it wouldn't have been possible for our government to distribute it at the scale that it is currently. And it also makes me wonder that such exceptions have been activated in the current scenario. So coming back to the appellate body being defunct, several questions might arise before the appellate body if it were to perfectly function at this point of time, particularly in relation to how much is an appropriate fair share for both the companies and an equitable balancing for states to be making use of vaccines or medicinal drugs. So, interestingly, on April 30th, so it's very recent, that a group of members, including primarily the European Union and particularly including China, have entered into what they call a multi-party interim appeal arbitration agreement, MPIA, in pursuance to Article 25 of the Dispute Settlement Understanding of the WTO. So the basic premise behind this MPIA is to preserve the essential principles, and I'm reading here, and features of the WTO dispute resettlement system, which include its binding character and two levels of adjudication through an independent and impartial appellate review of panel reports, and thereby to preserve their rights and obligations under the WTO agreement, unquote. So now, without going into the technicalities of this dispute further, my simple concern is this, that if hypothetically a case is pursued against China or other countries who might be found guilty of not adhering to early warnings or not containing the virus in time, especially mechanisms of redressal under the World Health Assembly, and then as a result of those adverse findings, if China or other countries withdraw from the MPIA, as a result, several allies will also withdraw, which might constitute a part of this 27-member group, which is gaining a lot of support, and it might lead to other members. So as a result, this interim agreement will also falter, and countries might find themselves in a situation of having to decide very complex trade disputes in an ad hoc manner. Essentially, what we're talking about is a manner in which they don't have well qualified arbitrators in trade law, which otherwise are there at the appellate body and might be there at the MPIA, but not in ad hoc mechanisms. And then such disputes might not be effectively adjudicated. So this is my concern with regards to this question.
Right, sir. This is a very interesting take on the entire issue. The World Trade Organization appellate body not being in function right now, the kind of effect it is happening on all the participating nations, how United States is playing its role, and how COVID-19 is actually affecting the entire situation. I believe this entire conversation about the substantial part in specificity has given me a lot of understanding as to how this international law is evolving eventually with COVID-19 and how COVID-19 situation is affecting this entire sphere, and in a sense is giving me an impression as to how I can understand that let's for example international dispute resolution is so important between the countries, and what exactly can and will happen if these bodies like WTO appellate body and this entire crisis does not get resolved really soon. Thank you so much, sir. Thank you. Is there any closing remark?
Yeah, just one aspect that I perhaps should have addressed before was sir. The aspect of proceduralities, which might change as a result of COVID-19, which is now being the new normal. Mm-hmm. And we will see a lot of changes in how international disputes resolution is conducted. Mm-hmm. I was actually seeing a webinar by very revered international arbitration experts, Dr. Yas Bani Fatemi and Professor Emmanuel Gaillard. of Sherman and Sterling. And they said in that webinar that at least the first procedural aspects of any international arbitration, such as fixing of a date and time, and several dates and times for that matter, for taking of evidence and for arguments, there are several procedural hearings as well, which can be dispensed with and can be done in virtual manners, which of course saves everybody's time, money, and energy as well. So I really hope that we are able to overcome COVID-19 very soon. But yet there are certain best practices which we might end up adopting as a result of what we are compelled to do right now.
Right, so because I completely understand the entire issue of procedure being coming up as one of the issues quite recently, not exactly part of the international dispute resolution, but in a similar sphere, the entire dispute between the football club, the English football club Manchester City and UEFA going to the Court of Arbitration for Sports, and the entire issue now becoming all about how exactly the procedure is going to be amidst COVID-19, and since Manchester City wanted their entire issue to be resolved as soon as possible. So yes, the procedure, in a sense, what you're saying is is giving us a very significant direction to the understanding as to how everything in this entire sphere will evolve because of COVID-19 and how everything will be effective. I'm really, really grateful, sir, because this has been a golden opportunity for me to learn about both the significant topics that we've discussed, also from your wide, very rich experience that you have. I'm really, really grateful that you could find time for a podcast, and you could find time to talk to me so that my listeners and I can benefit from this conversation. I had a wonderful time, sir, and I hope you had a good time too.
I had a great time, and the pleasure has been all mine, Kaustubh. And I especially say so because sometimes I receive some concerns, some queries, and I many a time feel guilty for not being able to respond to anything and everything that I receive. But this is a great platform for me to be interacting with as many people as I can. And so thank you very much for inviting me.
Thank you so much, sir. But and I must say this because a lot of my friends who study with me have asked me specifically to get in touch with you as well. And they, after I've got in touch with you, by the way, like I've already messaged you for this request, and they've reached out to me. They're like, "Oh, Kaustubh, you're doing podcast. You must reach out to sir, and you need to talk to them." So, do you have any closing remarks for my friends and all my listeners out there?
Absolutely. So you already have my details, and we can definitely be in touch, and I'll be very happy and willing to discuss, brainstorm with them. But there is a concern that I'm anticipating here. So I would like to address this for the benefit of the larger audience as well. And this is a concern about the lack of opportunities as a result of this outbreak, which everybody is facing. But I think the answer to this lies not in law, but in psychology. In a sense that if younger people are not able to work right now or are not getting internships, it's a rare and great opportunity for all of us to be spending quality time with our families. I can tell you that I have not cherished such a great and wholesome experience in terms of spending time with my family in a very long time, maybe in the past 10 years, ever since I got into law. So what I'm trying to say is that nobody and no employer is going to ask anybody post the lockdown as to why they were not so constructive during this time, because everybody will understand. So I think this is very important to understand for everyone, and just take it easy. And as I said earlier as well, this is a great opportunity to be doing things out of the ordinary. You are a live example of that by setting up this podcast. There are other people who are making a lot of notes by attending webinars, including myself. And these days, my favorite is a webinar by Professor Gary Vaughan on international arbitration, which is for free, which is like gold dust. And I must recommend that to people. But besides that, it's a great time for academic self-learning about the things that we really want to read about rather than being compelled to read about. Write about them, and hopefully we will come out of this lockdown and this entire morbid situation sooner than we expect, and then we will have these unique things to speak about to the prospective employers. So that is my concluding remark, and with that I thank everybody for joining in, for your patience, and I hope that this session was worth your time. It will be a great honor to interact you with in the times to come as well. So stay hopeful and stay brave, more importantly. And I wish that there are great things that come your way. Thank you.
Thank you. Thank you so much, sir. Thank you so much for taking time for this podcast. And thank you so much for talking to me. I'm really grateful, and I would love to stay in touch with you. Thank you so much, sir.